a strategy with regard to all these things. And once you do that, you'll have a certain amount of comfort, knowing that you've taken care of it. And your family will also, which can make all our lives easier. So I appreciate your comments. The other issue with regard to a funded plan is establishes a fair and binding price. Now, you got to look at that price and adjust as time goes on because things never remain the same. Things change, the value could go up, and you have to make sure that the funding has gone up appropriately. The other thing that it allows you to do is you can maintain ownership as it is. You don't have to sell a piece. You don't have to sell all of it. You could keep the exact same ownership level for your family without having to sell any piece. So that's something important. If you've got something that your family really wants to be involved in for the long term, you want to protect them. And lastly, it reduces potential disputes with the IRS regarding your estate valuation. And the IRS can be heavy-handed in coming up with a valuation. And when they have a value already established and funded, it's hard for them to argue that that's not the right value. So just something to put in your thinking cap. Another option is borrowing, but once again, do you have the ability to borrow? Okay, in today's world, it may not be there. It'll significantly increase your cost because now you have to fund the interest too, as well as the principal payback. Will it put additional strain on the financial ability of the business? Okay. Of course, there's no guarantee that you can borrow based upon the transfer of an interest, and you don't know what interest rates are going to be. Okay. And I, for one, don't think the interest rate environment is going to be very friendly in the next few years. So, these are things that you have to consider. Now, you could actually save money, okay, and put it inside your business and keep it, or put it into some sort of a non-qualified type plan. I think it's a good option, okay, but it does create the potential for additional tax because you're not creating something that would be a tax deduction for it. It's subject to claims of the creditors, so if a company came and sued you, all those assets could be at risk. And, of course, it's not guaranteed. Depending on what you have it in, it may not have the value that you anticipated. But there are ways to do that and to guarantee the value, which Dan will talk about in a little while. Once more, entity installments. A lot of risk here. Depends on whether the entity can continue in a profitable situation. Will put a strain on the business, and once again, there's no guarantee of payment. Now, I'm going to bring Dan in to talk a little bit here about how to fund this and the type of options you might have. Certainly, you might say, well, what happens if nothing happens to me? Well, Dan will address that too. So go ahead, Dan, if you don't mind.
Actually,
Thanks, Larry.
I'm sorry to interrupt, Dan, but we did get a quick question that I thought is going to segue into this really well. It says, I have a partner who wants out now, and I don't have the money to buy him out and don't want to take a loan. What should I do?
Well, certainly that's one of the issues that we're talking about here. Theoretically, that could have been funded as you go, okay? But certainly you could sell his piece of the business or he could sell it, but that creates some risk for you because you don't know who your partner is going to be. You certainly could borrow, assuming that you're credit worthy, and even companies that are profitable right now are having difficulty with regard to that. So, in terms of being able to fund it, it's a very big issue, and you're better off funding it over time than you are doing it all at the same time. And then you can adjust as you go. The reality is that people wait until the problem occurs in order to deal with it. But certainly there may be some strategies that we could talk about. I'm not so sure we want to get into that today, but when we get together at the final session, we could probably sit down and chat and come up with some ideas that may be able to help you.
Great, thank you.
Right, Larry. And also, if I could just add, it's also all just part of the planning of the business. It's just things that don't get addressed in the beginning, either because it's an uncomfortable question or They just don't want to talk about it. And in reality, it has to be talked about as a partnership is being formed. What is the exit strategy, for a variety of different problems that could come up. So it's key to address that in the beginning.
Okay. I'll move on, Dan.
All right, Larry. So if you could actually just go back one slide for me. I'm here to talk about buy-sell agreements, basically how to plan for the what-ifs if something happens to a partner or a significant entity or a principal in the business. A buy-sell agreement simply it protects your business from the premature death or disability of a partner or principal. Okay. The first order of the day is to create a formal written document which establishes a value for your business. It's not an easy task, certainly, but you can hire a professional business appraiser to do this if you can't come up with a fair value which satisfies all the partners. Each partner is then assigned a percentage of this value. After the accountants and the attorneys sign off on it, the buy-sell agreement now becomes a formal written document, and it directs the partners what needs to be done in the event of a death or disability, and the business, it must follow that document's directives. I'm very passionate about buy-sell agreements. I have a business client right now who is about to go deeply in debt to pay off a widow of a partner in his small business. They had a written buy-sell agreement, but they didn't fund it properly. The partner's attitude was, I'm healthy, like Larry said before, nothing's going to happen to me. So why should we even bother funding it now? Unfortunately, he was the partner who passed away, and the other partner had to write a check to cover both the long-term disability and then the eventual passing of the partner. Had they funded it properly, the financial impact of the partner's death would have been significantly reduced to the business. So buy-sell agreements, there are several different kinds that are out there, and I'm going to go over each one of them briefly. The cross-purchase agreement is one option. Basically, in the cross-purchase agreement, you create a life insurance transaction between the two partners. So in this case, this is what it typically looks like. There's two owners here, Tom and Dick. In the event of death or retirement, the remaining co-owner buys the deceased or retiring owner's interest. The agreement is between the owners. The business isn't party to it, so it's outside the business. Cross-insuring is the typical way to handle the life insurance in this case. Tom is the owner and beneficiary of a policy on Dick's life and vice versa. And what basically happens is if one of the partners dies, the life insurance proceeds are available to purchase the estate's interest in the business. So the insurance proceeds are exchanged into the estate for the shares of the business. So you basically are buying out the estate, and then the business becomes whole. The general rule in the life insurance is whoever needs the death benefit should be the owner and beneficiary of the policy, thus the cross-insuring approach. Okay, Larry, next slide, please. Okay. The entity stock option redemption buy-sell agreement. This is a little bit different. Okay. Here's the flow chart for the entity or stock redemption buy-sell agreement. It's called entity for LLCs and partnerships and stock redemption for corporations. Here, the agreement is between the owners and the business. The owners agreeing to sell their interest to the business in the event of a death, disability, retirement, etc. Before the AMT, or alternative minimum tax, while most businesses were C corporations, this was the structure of choice. Unfortunately, a life insurance death benefit received by a C corporation can be subject to the AMT, which triggered a rush to the cross-purchase agreement model. Okay, next slide. Now we have the wait-and-see buy-sale agreement. This looks more like an entity agreement, but the provisions are a little different. You will note that the business owner and beneficiary, the business is the owner and beneficiary of all the life insurance. So strictly put, as soon as something happens to a partner, the life insurance proceeds are paid directly to the business, and the agreement basically states that the estate is out of the business at that point. Okay. Now we have a variation